Good morning from Europe and good afternoon to you, our listeners in Asia. Welcome to today's webinar, iPolitics, Connecting the Dots, SEP Research and Development. We will now show you a short video.
Are you ready for the next technological revolution? It's right around the corner. Smart homes, smart factories, and even smart cities. A revolution that will rely on connected technologies like 5G, 6G, Wi-Fi 6, and many others, where technical standards and standard essential patents are at its core. Amidst this new revolution, if you think your industry will remain unaffected, think again. Enabling almost any use case of the future will need reliance on telecommunication standards and their relevant standard essential patents. And chances are, it will affect your industry too. So are you ready for it? Do you have the required freedom to operate for your next interconnected product? Do you have the latest SEP data and analysis to guide your FRAND licensing negotiations and make sure you're not being taken advantage of? Are you proactively assessing your baseline royalty rates? Being informed requires sifting through thousands of patents and standards documents and creating manual linkages between them. This can take months. How do you keep up with this rapidly changing landscape? At iPolitics, we recognize these challenges and have created a solution that makes it incredibly simple to be better informed about your freedom to operate, your competition, and your industry. With iPolitics, you have the right arsenal to take to your next FRAND licensing deal. iPolitics is the only tool on the market to comprehensively unite the world of patents, SEPs, and technical standards in a single platform. With our premier intelligence solution behind your back, you have everything you need to adapt to this new technological revolution. Let us be your competitive advantage. Learn more at iPolitics.com and get in touch today.
To those who have just joined us, welcome again to today's webinar, Connecting the Dots, SEP Research and Development. Before we move in to the presentation, here are a few housekeeping points. There will be a recording of the slides and the opportunity to listen put onto our website, which you will be able to access in a day or two from now, or alternatively, with your contacts at iPolitics, we'd be happy to send you the recording. The session today follows on from two previous presentation slide recordings which we've had on SEP portfolio management, connecting the dots, and SEP licensing, transaction and litigation, connecting the dots. These can also be accessed on our iPolitics website should you wish to download the previous recordings. So turning to today's event, our speaker today, Dr. Tim Pohlmann. He is the CEO and founder of iPolitics, which now goes back some 8 years or so. He has been involved in many discussion papers, forums, and reporting commissions involving the German government, the WIPO, and currently the European Commission. He is also a regular lecturer at various universities and IP-related academic universities and colleges. And in addition to that, over the last few years, he has published over some 50 industry articles related to IP and the world of SEP and standards. And you can find those in IAM Magazine, IP Watchdog, and Managing IP. So without further ado, let me pass on to Tim to lead the way. Thank you, Tim.
Thank you so much, Andrew, for the kind introduction, and welcome to today's webinar. I'm really happy you joined us today for the next session and the last part of the series of Connecting the Dots. We have a great agenda ahead of us. We will start to talk about, or I will start to talk about who is the one to file valid and essential patents in an organization. We will look at the people and their roles. We will look at why to file standard essential patents, what's actually the reasoning behind it. The best approach to file valid and essential patents, we're looking at how to draft these valid claims, how to determine essentiality, how to right-size a SEP portfolio, and then last but not least, how to leverage the data access to patents and standards cross-departmental to do all that. Who to file valid and standard essential patents? When we look at the organization of a company or corporation, we know that everything starts in the innovation process with the idea. We have R&D here on the left-hand side, where we have people that call themselves head of innovation, product manager, inventors, but also head of standards development, standardization. And those people in R&D very, very closely have to work together with the IP team, making sure that intellectual property is protected at the right time, at the right place. And that's really also where we can find this in the innovation process. On the left-hand side, in the time axis, inventions come from research and development, and then they eventually become filed as patents by patent attorneys, by the in-house counsel that basically draft claims on new inventions that are disclosed by the inventors. If you think about the use cases and analysis these kind of people have to do, we see that especially in the early stages of the innovation process, we need a lot of information about the technology landscape, what's going on in the technology space, new idea development, competitive monitoring is always important too, but also technology scouting, identifying new technologies, new trends, same as standards development and understanding new standards initiatives, innovation partnerships, and of course also that involves search and patent review. The next step in innovation process and very early on is of course securing your ideas in the prosecution team, in the legal IP team. These people typically have use cases and analysis around prior art search, validity, invalidity, and reporting. So let's have a deep dive into the different personas. The leader of that whole early innovation process, we would call the innovation leader. These are people that call themselves VP or head of innovation and R&D or open innovation, technology lead, head of research, head of product and technology strategy, or even chief innovation officer, head of standardization. What do these people do? Those are really the leaders in innovation. They have to set the direction of where the technology trajectory of a company goes, always balancing the commercial aspects with technology and of course understanding the underlying intellectual property. They typically have a pipeline of innovation and products that they will have to add to the company, and they have to make decisions like make or buy decisions or go and no-go decisions that relate to R&D resources, to standards development initiatives and taking part in those, and to product market needs. They, however, also really have to understand the competitive landscape, making sure the corporation and company is always in a good state to be sustainably winning in the market, understanding new players and of course also new innovations in the market. And those people are typically looking at newly developed technology internally, understanding IP risks, freedom to operate, and they have to very closely work with the legal team. It's all about managing to speed up the success of the innovation. And of course, these people need to directly report to the C boards of the company. Challenges are really getting good decision-making on go and no-go decision or build versus buy decisions, and not waste time on R&D projects. So these people really have to make decisions that have an impact on how well R&D and time is spent, making sure the company invests into the right innovations. And to do that, they need information that is high level, that gives them a summary of new products, new patents, new standards, a good summary of the competition and the technology trajectories in the industry. Use cases are typically here: technology landscaping, competitive analysis, technology scouting, partnership analysis, and technical standards implementation. The people that report to these innovation leaders are typically the product or the standards managers. These are still decision makers, but they're also influencers. What they do is they deliver the new product or the new standards to the market in typically a stage gate process. They have to ensure clearance on standards and products and IP. They work more closely with the legal teams, and they are responsible to really getting the products or the standards to the market. They also have to always understand how a new product or how a technology standard fits to the overall company's products. They have to also keep up to date with the competition in the market, and they have to make sure that they keep a solid commercial understanding of innovation, both to make decisions on cost and revenue that is expected from it. Also, they have decision-making to do. Their challenges and goals also include make or buy decision, go and no-go decisions, freedom to operate analysis. And they also have to have a really good understanding about the white spaces, new technologies, new standards projects. I'm quoting here, just tell me where I can invent, right? Understanding where do we have still possibilities and opportunities to invent, and then also, of course, to protect our inventions with intellectual property. That's also why use cases here are also technology landscaping, competitive intelligence, technology scouting, innovation partnerships, and standards development analysis. The inventor is actually the person that comes up with a new idea, right? It's all about research and development to solve new technical problems that haven't been there before, and that can eventually make products better, right? They work with prototypes, they collaborate with other engineers, they have to submit invention disclosures to something that we would call a patent board, making sure that everything that is invented is also protected. So they have to work with legal, but they're not legal people, or they may not have a legal understanding of the invention, in particular. Also, they have to look at competing innovations just to keep up with the technology trends. And they have to always stay up with the latest innovation activity that's going on in the market. What are challenges and goals here? Again, they're not IP experts, but they need to understand IP landscapes in a way. And they need to understand the prior art really that exists out there. They need to conduct quick and accurate IP searches. They really have to understand if they come up with an idea that is really novel. And they have to really understand what it makes to have that invention become a patent, right? So these are really people that are working in R&D and that are in the depth of the technology. These are not necessarily decision makers. They're more influencers. Their use cases are technology landscaping, competitive intelligence, technical standards implementation, and search and the review of patents. And last but not least, the people that actually file the patents once the idea is there is typically the in-house IP attorney. They have to review the inventor's innovation disclosures, making sure that the innovation is not only novel and it's an inventive step, but also that the claims are drafted correctly, that they can be mapped to a product, or that they can be mapped to a standard, or that they can be mapped to a future technology that is of relevance. They do have to really be working precisely. They have to look at prior art. They have to do freedom to operate searches, and they have to really work with the invention review committee closely together. These are typically people that are risk adverse, and they have to really do exact work. So accuracy is one of their biggest goals and also challenges at the same time. They have to really balance IP process with commercial needs of the business. And they have to, make sure that or take over the responsibility that an innovation is taken from innovation to become a patent. So what they do is typically in terms of use cases, portfolio management use cases, and prior art searches. Why would we even need to file valid and essential patents? And that, I think, is a good question. Before a company spends all the money on this, why would they need to do that? There was an interesting study published last year, 2021, that showed in a survey of the market that over 75% of the patent owners agree that a well-balanced patent portfolio reduces the risk of litigation. Further, strategic investment in patent mitigates exposures to damages and royalties at an estimated 5% of the company's revenue. And of course, especially when we talk about SEPs, royalties and litigation are important keywords for everyone that implements and uses standards. However, IP-owning companies have spent over 40 billion on patents worldwide each year. And of course, right now, in times of inflation, right now, in times of economic crisis, companies are drastically reducing budgets available for R&D, available for standards development, but also available for building and maintaining a patent portfolio. And that, of course, creates a lot of challenges for people that have to focus even more today on the right initiatives in R&D, in standards development, and filing only those ideas that are valuable to the company as patents. However, one question I think is, are SEPs more valuable than other patents? One thing to note here is that SEP-related global royalty income last year was estimated at $20 billion US. So that is, of course, a significant amount of royalty income that makes it very lucrative to not only own, but also to license standard essential patents. And that number is foreseen to be even increasing by market experts as the compound annual growth rate will grow when connectivity standards such as 5G, Wi-Fi 6, VVC, the G standard, other technology standards go beyond the smartphones, are integrated already today in automotive, in IoT, in manufacturing, home appliance, energy, and healthcare. So that number will even increase. And that number does not include cross-licensing, bilateral negotiations of companies, because that also has a dollar value that is hard to estimate. And that's also why we have interest in filing patents on both sides of the table. The SEP holders, let's call them here the net licensors, will actively monetize and enforce their SEP portfolio, which makes sense because they have spent a lot of R&D money into owning those patents, into contributing to the technology. But on the other hand, the SEP implementers, let's call them here the net licensees, they need SEPs as bargaining chips in complex SEP negotiations, and they want to have a seat at the table when connectivity technology is developed as well. And that's also what we see in the data. In particular, the auto industry, we see more and more SEP filings coming from automotive manufacturers. And that shows, again, that SEPs are important not only for the big telecoms, they are important for any industry vertical that will be affected by connectivity. Let's look at some data here. Quite interesting. If you think and look at the economic patent research and validity and essentiality, it shows that SEPs are twice as likely subject to change of title, meaning patents that are declared essential at least are sold and acquired twice as often as other patents, showing again the commercial value of these patents. SEPs also have significantly more claims compared to other patents to have the subject matter covered, and SEPs are amended around 25% more than other patents. However, patents or declared patents are twice as often challenged for validity compared to other comparable patents, showing that it is kind of an exposure to own an SEP because people may try to kill your patent because it may be uncomfortable in the market when you enforce and license it. Also, what we see is that essentiality rate of declared patents has been decreasing from about 30 to 40% in 2015 to only 10 to 15% as of this year. So how do we approach filing essential and valid patents that are, reading on a technology standard? Well, I think the first lesson to learn is that filing and maintaining patents with claims that read on the implementation of a standard does not happen by accident. You cannot expect that you search in your IP portfolio and you by chance find an SEP. That's very unlikely. Because filing SEPs really requires you to do a long-term investment in standards development, supported by an active and very strategic prosecution process. Because you have to align your patent activities to the standards development activities and integrate all that in your R&D and business plan. And that is really expensive. That is very challenging. But what we see is, due to the importance of connectivity, such just as an example, 5G, and the potential value this brings to all kind of market industry verticals, we do see a lot of movement, even though economic crisis, even though, budgets are cut, we see a lot of investment into standards development and patenting for those technologies. Just to give you some data, the number of submitted standards contributions for 5G, and I'm talking here about the cumulative numbers, so all contributions that have ever been submitted, is already almost twice as high as all contributions counted together for 2G, 3G, and 4G. So 5G alone is bigger than any earlier generation before combined. So you see, getting to meetings, contributing at those meetings is a lot of investment for standards developers. And, it shows how much money goes into this. And also from counting the patent families that have been declared, this is only 5G here in this graph. But again, the cumulative number of patents declared for 5G, we arrived over 50,000 patent families, by the way, that are active, but both pending and granted, but still 50,000 patent families. But that number, again, is bigger than 2G, 3G, and 4G combined, if you count those numbers together. So again, very impressively, that most patents exist declared to 5G than to any other generation combined. And also what we see is an increasing market. So we have been, in this analysis, very conservative. We only counted companies that have declared at least 10 patents to be essential at any of the SSOs out there. And we only looked at parent companies, not at subsidiaries. So if one parent company has declared patents, we don't double count the subsidiaries. Even with that very conservative approach, we do see that the number of companies that own at least SEPs or 10 families has been increasing by factor 2.6 over the last 10 years. So, and who are these companies? Again, these are not only the big telecom companies, these are automotive OEMs, automotive suppliers. We also have small, medium-sized chip manufacturers, companies in the IoT sectors, companies in energy, companies in home appliances. So we do see new industry players enter the market, which is quite interesting. So how does it work? How can one even be able to file patents that, after all, read on a technology standard? I think to get started, we have to understand the dynamics of that process first. Standards development is not setting a standard and then the standard is set. Standards development means there are meetings, typically in different working groups, that are happening on a continuous basis. Take the example of the 3GPP, you have about 8 to 10 meetings per year. Before those meetings, you can submit contributions that are then voted on at these meetings. So after those meetings, typically new versions of standards are, published, and eventually a release is published and then freezed. So we have continuously added technology to the standards development process and to a standards generation, let's say 5G, that has been developed since 2015 on a continuous basis. We see more and more technical contributions coming in for that technology. And these contributions and that technological input is, of course, in many cases covered by patents. So also here, patents come in on a continuous basis. Every time there's a new standard, we may have a new patent that is reading on that standard version. How does it work in the process within the corporation? It starts again all with research and development, with the inventors that come up with new solutions that improve a technology, which may be a product, but which also may be improving a standard. Those have to be disclosed to the patent board that decides, should we file for patent or not, right? And they make that decisions, first of all, of course, on legal basis. Is it novel? Is it an innovative step? But also on a commercial basis, how can we use this patent? Either to protect our products, to protect future technology avenues, or to contribute to standards development. If contribution to standards development is a case, that invention that is then filed for patent directly, what we call a priority application, the first filing in the US, they call it provisional, they can then only carry that to the standards meeting, making sure that the idea is protected before they present it. But of course, at the standards meeting, just because you present it, it doesn't mean it's going to be accepted and agreed upon. So a patent attorney who wants to do claim charting has to wait until the first version of the standard is published to understand if the patented invention is part of it, and then can only claim chart that invention disclosure or that first filing to the first standard version. But again, versions change. The next standard version may look different. So patent attorneys can use also, or have still, flexibility in the filing process, even with claim amendments, to adapt the language to the latest version of the standard. So we have another claim chart, making sure that the latest version of the standard works. And of course, patent attorneys also have to work with the offices. Not all claims that you apply for are granted. And then you have to, see if your final granted claims made it in a way so that they secure claim elements part of the standard section, and thus you can have your patent claim charted perfectly. And then, that's what we discussed in earlier webinars. You can sell, litigate, and license your patents afterwards, or keep them for your cross-licensing negotiations, of course. How do we do that now? How do we draft valid claims? Well, validity, to start with, is not given. The immense amount of potential prior art documents create a considerable risk for anyone who owns SEPs that you're losing your patents for good, either because prosecutors did not draft claims properly, or the office, the patent office fails to identify all prior art. So you cannot rely on that, right? You have to make sure you have a process that ensures that your patents are valid. Because 76% of all IPRs filed against SEPs used non-patent literature as prior art, and 66% of these proceedings specifically used non-patent literature that were produced explicitly for the purpose of standards development, like technical specifications, like standards contributions, reports, or working group documents. So you have to make sure that you are aware of these documents when drafting your claims, and not being made aware when someone is challenging your patent. How do we do that proactively is the big question. To understand also, if you look at prior art that is actually cited in patents, a colleague of mine did an analysis here where they looked at ETSI declared patents, and they found that most of these citations actually cite technical contributions, over 29,000 here. 26,000 cite technical specifications, then we have meeting proceedings, and then we have technical reports. But it shows that, a large number of these patents actually cite those documents as prior art. Also, one reason is not only the filing corporation or the filing entity, it's also the patent office themselves, because they started to look at that data more closely. They have what they call memorandum of understandings with, for example, the European Telecommunications Standards Institute, ETSI, which develops 4G, 5G, or the IEEE. And these agreements typically give you access to, full text information like standards documents, or, other standards related forms like technical reports, contributions, drafts, anything that could be part of prior art. However, in a systematic way, only the European Patent Office has integrated a database that gets up-to-date information on standards and contributions. The USPTO never did that, really, at least not systematically in a database. And that's also why a researcher looked at the effect of that. And it's quite interesting. If you look at the left visual here, it shows the filing of later declared essential patents. And it shows, the acceptance rate, which after 2004, when the European Patent Office got that database of fully indexed standards and contributions, the acceptance rate went down compared to USPTO. Like in blue, the EPO, and red, the USPTO. So we do see that a lot of patents, didn't make it because the Patent Office apparently found prior art showing that the invention that was submitted, it wasn't novel. While in the USPTO, that wasn't the case. Compare that to the right visual, patents that have not been declared essential, but are similar in a similar area. There's no difference in acceptance rates of the European Patent Office than the US. So it really shows in a different diff analysis the impact of that policy change, that access to standards data, fully indexed contributions, fully indexed minutes, and conference proceedings of these standards meetings is important to file valid patents. What are the challenges, and why would you even care? Well, the number of technology standards implementers that find themselves entangled in SEP disputes has dramatically increased over the last 2-3 years. And one reason is it goes beyond industry. It's not only smartphone industry anymore. And the biggest risk to anyone who's using or who is a potential infringer of those SEPs, of course, is the threat of injunction that is actually right now very real in some jurisdictions like Germany, like the UK, like South America. You know, these jurisdictions file a lot of injunctions. So filing an IPR is one way, or an important way, for any implementer to defend themselves, right? However, on the other hand, the SEP holders have to be aware of that and have to, you know, conversely mitigate the effect of IPRs, you know, making sure their patent portfolio is valid. So we have, again, risk on both sides of the table. The implementers have the risk of injunction, and the SEP holders have the risk of invalidating their patents. There's also some interesting data about IPR statistics on SEPs, by the way, here. It shows that if you compare SEPs with other patents, that they have a similar cancellation rate, but the likelihood that for an SEP, all claims are canceled are much higher. So again, the likelihood of losing your SEP for good are quite high, and you have to make sure that doesn't happen as an SEP owner. How can you do that, right? We've seen the numbers from the European Patent Office and how, you know, how more strict they got on filing patents and how that acceptance rates drastically decreased compared to the USPTO. Multidimensional access to fully indexed standards data, standards contribution data, meeting minutes, email communication is crucial in the area of SEPs to file valid claims and to draft valid claims. So I want to present you now 3 strategies of how you can use that fully indexed databases to identify prior art. First of all, looking at standards meetings proceedings as a search strategy. Then looking at the inventors on a patent as a search strategy, and then looking at actual claim elements that you search in a full text, fully indexed search. For that, we look at our IPlytics platform interface. And what I do here, I just choose a random patent that I search on our SEP database. That patent was declared 5G, actually, to the 15th release of 5G. And what we can do with our semantic comparison of claims and sections, we can also look at that. The patent has been granted in the US and China so far. And again, here we look at, in our semantic analysis, the most relevant claim of that patent that we compare to the most relevant section of that patent. In this case, the section 9332, right? What's interesting also is that exactly that section has been also declared by the declaring company, right? So we see that in the declaration information even. And however, what is interesting now, we can scroll down further. We see the earliest priority date. So we want to look at validity, not essentiality here. So we need to make sure, you know, when the patent has been filed first. You see in a non-patent literature that this particular patent has cited a ton of information from standards development, meeting proceedings, even contribution identifications, or TS and TR numbers. We want to concentrate in this analysis now on the meeting information. So among other meetings, the meeting 71 has been cited here. So what we do is in IPlytics, we go to our standards database. It's all fully indexed. We go to the meeting information. We type in RAN 71 meeting, you know, that happened in Göteborg. And we search all documents that have been published at that meeting, right? Remember, the patent was filed in August 8th in 2016. What we see here, all the meeting proceedings and contributions have been submitted, you know, already in March. So it shows us, you know, all of that could potentially be prior. Let's have a look at some technology concepts that are both disclosed in the claim and in the section. And we find here, for example, the protocol data unit, PDU. So from these 999 contribution documents, we want to find that particular technology now. And we do find indeed 9 documents that disclose that technology in the contribution document. Here one from Ericsson. And if you go and deep dive into it, you know, again, we see, yeah, that could potentially be prior art. It's from March. Our patent was only filed in August, or not filed. Priority date was in ours. And you see here, yeah, it does mention the PDU. right? So that was marked in the full text of that contribution. And of course, you can now go down that list of all those 9 documents, have an expert, a subject matter expert, look at it and really check if the technology or the claim element described in the claim can be found in that contribution document. So that's one very efficient way to quickly find potential prior art. Another way is not looking at the meeting necessarily, but at the people. What we find in our data very often that those people who are the named inventors of a patent are often also the engineers that go to the meetings and have contributed to the meetings. So again, same patent, priority date, 2016, August 8th. Now we look at the inventors. These 2 inventors, we want to now search in our standards database again, and we want to see all the documents that they have published in the last years to see if some of these documents could be prior art, right? So we search these as the authors of the documents, right? What we of course have to make sure that it's not only these names, you know, some people have very popular names. So we search also the entity that they work for, in this case, Nokia. And we see those guys have been very busy, 440 documents, but they are still busy. They're still working today. So we have to make sure we find only those documents that could really be potentially subject to prior art, meaning all documents that have been published before August 8 in 2016. So what we can do quite easily, we can set a date. We can set the date range to a date from the past, but not later than August 8th of 2016. So we can set that date quite easily and refine our search, you know, from the 440 documents that we found to now only 35, right? So that makes it quite easy to very quickly now find documents that these 2 inventors have produced. And again, you know, to get even more precise, we want to go back and, you know, only search for a particular technology concept or a claim element that is disclosed in the claim. And, you know, we add that technical information. Our data is fully indexed, so you find really the whole description of any contribution. And we end up with only 1 document, which makes life, of course, much easier. You can now deep dive into that document and check if that document really discloses anything like that. And actually, the data shows already that the PDU is in itself not really disclosed. They talk about protocols and data and units, but not about, you know, PDU per se. Last but not least, I want to show you the approach on how to identify potential prior art just by searching the technology. What is interesting with our semantic claim section analysis, we already proposed to you the most relevant claim and section, which makes it easier to find prior art because you can really, you know, focus on those that where we already have the claim and we see that this particular claim element was disclosed in the section. So again, we look for a PDU and we combine that with another keyword. And this is just an example here. There's many ways to search in our software, you know, very sophisticated. But, you know, I just want to give you an example. And you can search those. Again, we set our date, any document that should be published earlier than August 8th, 2016. And we find 24 documents here, right? So very quickly, you can see only searching for certain claim elements. If there is prior art, we make sure these have really been published beforehand. And again, we can go into the details and see if that contribution really does disclose something that we can file for prior art for that patent. So a quite efficient way to identify prior art, if you follow certain strategies, search strategies, you know, those videos were 2-minute, 3-minute videos. It shows you how quickly you can work with this. So validity, that was validity, but now essentiality, you know, how can you really determine essential claims? I think, first of all, we have to understand that we have 2 moving targets here. First of all, claim language and claims change in the whole granting process. Offices may not accept all the claims you apply for, or you have to change those. Also, standards continuously have new versions that may introduce new sections that are potentially mappable to your claims, right? So we have 2 moving targets, changing claims, changing standards and new standard sections. Also, we have a complexity in the world of standards development. When we look at our data, SEPs are declared on average to over 6 different standard specifications, not even considering versions. These are really different 5-digit level specifications. Standard specifications have on average 160 sections. Patents on average have 5 independent claims. If you combine all that, only for the ETSI database of about 250,000 patents declared, we have 1.8 billion combinations. So having a computer helping you to identify the most relevant claim section combination makes a lot of sense, because a computer can go through all these versions of all these different releases, go through all documents in full text, take out the section language and compares those to claims. Also, what the computer can do is the computer can expand declaration information to whole families. At ETSI, typically, companies only declare one basis patent. Let's say you are a US company, you would declare your US patent. You're a Chinese company, you declare a basis patent from China. Doesn't mean that the counterparts of that patent that have been filed in Europe, US, Japan, Korea, around the world typically, are also part of the database. Actually, the ETSI database promises that there is an API to the worldwide assessment that takes care of that, but that is not apparently working well. We identify over 50,000 patent family members that have not been declared, that are not part of the ETSI database, that you have to consider. If you do claim charting, you have to make sure you have all family members there, because every family member may have different claims. However, SEP determination, we all know that, is very expensive. If you do it manually, you need subject matter expert review, claim charting, attorney legal opinion, and review. And that can be very costly. 200 patents up to €500,000, and you need a whole year. Why do we know that? We actually did a survey with claim charting experts around the world, from the US, from Europe, from India, and we did a survey and asked them about different levels and rigorous levels of claim charting and how much it would cost. So a very light evaluation you can get as cheap as for €31 apparently. However, if you think about real claim charts, they start only at rigorous level D. You have to spend at least something like €1,000, or on average more than €4,000 to have one claim chart. However, it's not only about the cost, it's also about the time. Category D, which is really the lowest level of claim charting even, you need already 600 minutes for one claim chart, meaning a whole day. Again, 300 patents, you have one expert work for a whole year, right? So you need a lot of experts to get a portfolio of 300 patents evaluated quickly to make that somehow reasonable. And that's also what we found when we were asking the industry then, what are the biggest challenge of SEP determination that is manual? And they said, it's not the cost, it's the time that it takes to chart patents. That's the biggest challenge. After that cost, after that, finding experts to do the work. That is why we at IPlytics really strongly believe that semantic essentiality scoring can be a first step towards SEP portfolio determination. We are very aware that patent attorneys draft claims and they use a very different terminology, typically a broad one, making sure the claim has a legal breadth that covers a lot of technology, while standards and the sections and the way they're specified are on purpose specific. And these are engineers and not patent attorneys. They use very different language and expressions. And that's really why at IPlytics, we took a lot of time to develop an algorithm that takes care of claim language and section language and creates a vector space trained on actual claim charts and subject matter expert work that allows us to run semantic analysis that can compare sections and claims in a way that goes beyond keywords, that goes beyond concepts, that goes really into the information in there. Why is that interesting? Because you can really have claims and sections side by side, as I showed you in the video already. I'll show you another one now. And that really helps your work. It really shows you where to look at. It also allows you to look at this in the grid and filter results as to certain essentiality rates. And now I want to show you how that works. I took a portfolio of, I think, over 600 patents, something that, impossible to manually claim chart, at least not quickly. I just copy paste those in our interface. It's really easy. Just copy paste it. If your patents do not all have the right format, we correct the format also. You see that here. We have exact matches. We have corrected numbers to our patent number format. You just import it like any other tool. What we do now, we search for those patents. And we get over 600 patents. And it already shows you that those over 600 patents have been declared to multiple standards, right? Over almost 8,000 documents we have. You can then sort your result grid list by semantic essentiality score. And for every patent you get, this claim on the left-hand side and the section on the right-hand side that show you that are most semantically relevant. This one, 94%, is actually very relevant, right? And it really helps you directly where to look at. Even more easier is that you can set a filter on the right-hand side of a certain semantic essentiality score, meaning you only want to see the top scoring patents. You set a filter, let's say to 75%, which in our analysis is typically very likely essential. Or you find, on the other hand, those low scoring patents that you may want to, not maintain, that you want to skip, that you want to kick out of your portfolio, or that have been offered as a license, and you say, oh, well, these are probably easier to show that are not essential. I can also do that on a higher level, on the portfolio level, right? I look at all the patents I imported and the different companies, the current, owners here. What I have here is what we call the matrix graph, which allows you to really, like in a scoreboard, look at the different companies and the characteristics of their portfolio. 3G licensing here has the most highly essential portfolio with 78% on average and a good market coverage. So they really have their patent families protected worldwide. And you can compare that with other portfolios. What is interesting now, from that high level analysis, you can also go back and drill down. Let's say you only want to see the 3G licensing patents because they are most relevant to you. Maybe they offered you a license and they want to enforce their rights. So you have to be aware of what they own. So I only look now at the 17 patents they own, right, that I uploaded. And I look at those particular patents and I see, again, they have a lot of high scoring ones. And I can go into the deep dive and look at the claim and the section combination, right? So that, as you can see, is quite easy to do. I can do other things now, look at expiration and you see, okay, their patents may look very essential, but they expire soon, right? Many of them actually already in 2 years. So a lot of information, again, you can quickly observe and look at. Why is all that important? It's not only about licensing in or understanding what is to offer, but also to right size your own portfolio. Because a properly managed SEP portfolio will generate revenue for you on the one hand, but it also has to balance maintenance costs on the other hand. Right? And that needs an organization to make very critical, but also risky decisions on where to file patents, when to invest in R&D and standards development, and then align the prosecution to it. Also, it's important to have a seat at the table because you don't want to be, left out of the process when the next generation of connectivity technology is developed. We did a pretty interesting analysis with an economist where we looked at the max or the minimum number of patents a company should own to have at least one essential patent. Because we all know that from at least the declared patents, a very high share is not essential. And also we talked to experts, maybe something like 30 to 50% are also invalid, right? So we looked at different scenarios economically. Pessimistic scenario of validity, 30%. Optimistic scenario of validity, 80% of your portfolio. Essentiality rates from 10% up to 50%. When we look at all the combinations, you see here, when you have 250 patents, even in the most pessimistic scenario, one of them will turn out to be both essential and valid, right? So in order to have a case, in order to have something that is really essential and valid that you can survive in court, our analysis shows that you need at least 250 patents in a very pessimistic scenario. If you have knowledge about your portfolio that it's at least 50% essential or 50% valid, of course, you can have smaller number of patents for a portfolio, but a portfolio for SEPs is typically crucial to survive in court all the challenges of validity and essentiality. So it's undisputable that manually determining SEP is economically not feasible up to a certain number of patents. And also, subject matter experts are not always right, especially when they're only given 20 minutes to look up a patent claim, right? So semantic claim section scores are not perfect either. Of course, they have an error rate. They're not always right, but they can be a first step analysis. And you've seen that I just uploaded 600 patents and I got a very quick, efficient result on those patents that look very essential. right? And that, helps you to be much more efficient should you want to do claim charting. So again, the semantic analysis of claims and sections may not replace subject matter experts. It may more enable them to work much more efficiently, or it allows you to determine portfolios that were economically not feasible to determine before. So semantic essentiality score is a great proxy to do that, and really puts you in a good position before you do actual claim charting. Why would you care? Why is that important? Because connectivity is everywhere. Connectivity is not only 5G, connectivity goes beyond that. We see in the auto industry standards on parking assistance, standards on inductive charging, that are particular for that industry vertical of automotives, that where we see essential patents from automotive suppliers. So connectivity will go beyond the 5Gs, the Wi-Fi's, the video codec, and will go to industry verticals individually too. So any company in any industry vertical has to keep up with that technology trend. They have to be aware of the standards activities, and they should ensure that they file their essential patents early in the process. And that, we believe, needs access to both patent declaration data, standards contribution data, information on meeting minutes, on the actual different versions of the standards, pool data, litigation data, you name it. Really to have a seat at the table where the next generation of technology is developed. How do you get that into your organization? Well, typically, if you divide the world in two parts, the licensors and the licensees. Licensors, of course, have more of a focus of SEP development, SEP portfolio development, because they have to really align R&D, standards development, patent prosecution. And they do that already, of course. If you think about the top 20 SEP owners, they have a very strategic, approach to filing SEPs. That's not by coincidence that they own these patents. They have to monitor the competition. They have to justify the cost, but they do it because it's a lucrative market. In the standards team, they really need software and access to data like IPlytics to monitor the competition and to understand and really identify new technologies that come up in standards meeting and standards development now. They use IPlytics and prior art searches, on different levels, in R&D, but also in prosecution, really making sure that they draft patents that are really valid. And they use IPlytics to align their standards teams with the patent board in prosecution, because any decision needs information and data. If you decide to file a patent in the patent board, you need information to justify that. If you file for a patent, if you amend a patent, if you get your patent granted, if you sell your patent, all these questions, you need justification. Or if you want more engineers to go certain standards meetings, it's expensive. So you have to justify that. Patent prosecution uses IPlytics really to be aware of the dynamic nature of continuous, versions of standards and, changing patents in the patent prosecution process. And of course, they use IPlytics a lot for the prior art searches that I just showed you in some of those videos. But also the licensees, they have to really identify patents that are subject to standards they implement, right? And they have to do that already in the technology divisions, to make, decisions that are informed about, well, I'm using that standard now, and I have to be aware it's subject to patents that I need to pay for. They also need, however, to be aware of their own industry's standards activities and take part in those. Be part, have a seat at the table where V2X or M2M is developed. And then in that process, align your standards activities with patent activities, which for companies outside of the telecom industry is something new. They have to do that. They have to get to do that. IPlytics is used again also here for the implementation of standards, identifying which patents have been declared for those standards, and to identify, be proactive and identify standards that they should be part of, which always includes also monitoring your competition. And then the patent teams have to make sure patents they offered for license are really valid. So, invalidation searches, and then align if they want to be proactively filing patents. Again, standards development, R&D, and the patent prosecution teams. If that all sounds interesting to you, if you want to see if IPlytics can help you with all these processes, do not hesitate to contact us either on our website, call us, but you can, of course, also directly call our teams around the world. We have people on the ground in Japan, in China, and in Korea. So do not hesitate to contact them directly if you want to. Also, you can meet us or some of us on different conferences that are upcoming. There's this Wiesen IP forum taking place in Munich. I will be holding a panel there on SEP in France. There's the IMSEP Summit. It's an online event. You don't even have to travel somewhere. It's going to happen in mid-September. Join it. I also here will moderate a panel. We have the LES annual meeting in San Francisco that I will also be speaking at in a panel, and the Global France Symposium where I will be speaking at, also in Palo Alto in the US. That takes place in mid-October. And then we also will be traveling to Asia, here in particular to Japan. IPB Asia this year is taking place in Tokyo, same as the annual Patent Information Fair and Conference. Both of these events are in November or mid-November. So join us in these events, take part, say hi, we can talk in person. Also be aware that we will have our next webinar series up and coming in September. We call that the Bridging the Gap Between Patents and Standards Data. So, watch out for that. And of course, last but not least, the SEP Couch, where I interview industry leaders on topics around SEP, FRAND, litigation, patent pooling. Watch out for that podcast episodes too. A new one will come actually next week. Andrew, I hope we do have some time left for questions from the audience.
Extra question can always be put into the Q&A section below, but we have our first question here. Thank you very much for the nice presentation. It is really helpful. My question is, if my patent claim matches standard version 1.0 well, but doesn't match version 1.1 due to the approved changes of request submission to the standardization meeting after version 1.0, and in this case, can my patent still be called an SEP?
Yeah, I think it is an SEP for that particular version. And we have to always look in, an SEP, of course, is a patent that is infringed when the standard is implemented. And then, of course, we have to look at the implementation. If a certain company implements your version 1.0, then you have an SEP, and that SEP reads on the standard, and that company that implemented the version of the standard 1.0 has to pay royalties. However, if they did not implement 1.0, if they went for 1.1, and your patent is not essential, you may not have an SEP for that particular standard version. Of course, typically claims are written so broadly that they can also go, beyond versions. Typically also what we see that especially later versions, so an upgrade to an earlier version, may not change much existing sections, but rather add new section to it. So your example typically would be version 1.0 is not essential, while version 1.1 became essential because a new section was introduced that covers your invented technology or your patented technology. So what I want to say is typically when we look at standards and earlier versions and later versions, that standards increase in size and complexity rather that they take out certain parts. But yeah, you can still call your patent SEP if it's relevant to only one version. That's sometimes also why it is not so unimportant to understand first how a company implements the standard and what's important to that company, because we have, especially when we think about new use cases in IoT, there is, for example, not a video transmission between two machines or a traffic light sensor, right? There's no video data that is transferred from 5G. So the big question is all of 5G relevant? 5G is also all about video, that is transferred. So it's a good question to think about versions and that are really relevant to different use cases.
Thank you, Tim. When it comes to R&D departments and technology, would you say that the key initiation interests lie in prior art and standards, and then interaction, of course, with IP attorneys, law firms, being the interest being passed on in the process of SEPs and patent filing?
Yeah, I think if we have to think about R&D teams that work in standards development, right? These are standards developers per se. So it's very often teams that work on telecommunication technologies, either There are also the engineers that go to standards meetings, or they work closely with the engineers that go to standards meetings. Of course, for them, data about who is contributing, who went to those meetings, what has been approved and accepted is of the highest relevance for them in the first place. Not only for prior art and freedom to operate searches or just understanding who's doing what, but also for managing teams, for looking into, do I have the right people at the right working group, or should I shift, my focus on technology? So a lot of technology decision-making can be done using that data. But then, of course, the prior art searches are most relevant to prosecution at the end. Typically, the way it works, a patent attorney would request from the R&D guys, from the inventors, also some documents and suggestions for prior art already. Even though it's the prosecutor's responsibility, typically they also request from the inventor who knows the invention best to also look for prior art, right? So, and I think that's a good practice because, again, inventors have a different view on things. And they use different words. And so it's important that also inventors are part of that process. But in the end, the actual prior art search is done by the patent attorney, not the inventor. So they have the responsibility, and they also are the ones that are using our software, making sure, the patent files drafts the claims according to prior art.
Thank you very much, Tim. And thank you to our audience from the Far East today for attending. As mentioned, access to the recording and the slides will be on our website, or alternatively, you can contact your main contact person at IPlytics, and we'll make sure that you receive these for your own time or for colleagues that you may wish to share the slides and recordings with. So I'm now going to pass back to Tim. Thank you for your time, who can say thank you for coming today. Tim.
Yes, Andrew, thanks. Thanks everyone for coming. Please join also our next webinar series coming up in September. And I hope to meet you at some of the conferences, or, meet you at some of the virtual Zoom meetings when we show you what we do at IPlytics. So thanks for joining, and you have a great day. Bye.